Hi, this is Jesse from Rex to Rides. And today I'm actually doing a video about vandalism cars on Copart. They're reported as vandalism, and quite often they are actually um, theft recoveries, and they're not reported as theft recoveries. So, in my video, I'm going to go ahead and go through um, how they're not, and you will see it. I will try to cut out as much as possible and make it as compact as possible, but it's fairly dense and there's a lot of information in there. So please stick with me, like, subscribe, and hit that bell so you guys can see when I have new stuff coming out. Um, Please make sure that you help me out. I am getting there, trying to do new things and um, increasing the knowledge I have about creating content. So if you can help me out, I appreciate it. It's not a big thing to do, just bash that like and subscribe button. All right, thanks. Okay, I found a car. It's a Kia Sorento. Go figure, Kia, right? 65,000 miles on it. It says vandalism on it. This is one of the key aspects I've been talking about. Vandalism. Rather than say, hey, it was a theft recovery, they say vandalism. The part that's really confusing about this is when they say vandalism and they don't disclose um, theft recoveries or theft in general, that's fraud. And they say, oh, well, we sold it on a salvage certificate or we sold it on a bill of sale. No, sir. That is not legal. It's still fraud. It violates consumer protection laws. Now, it does depend on what state you're in that it does this. But I think this one is in New York. Let me double check. Anyway, still run and drive. Does have the key. But the funny thing is okay, so we're going to go over the key details to this vehicle. It says run and drive. It says it has keys. It says vandalism. There's the one key thing that I'm looking at right here. The column. It's missing the shroud. And this is what happens when they do a vandalism on it, or a theft, actually. Let me rephrase that, theft. Now, the other thing is I haven't looked for if it's missing any windows. So all the windows seem to be here. They're all on that side. Let me keep going back. I can't tell if that one's there. It looks like it's there, but I also don't know. Oh, this is actually missing the handle. So maybe they got in through the handle? I don't know. So that they have a little bit of damage here. Definitely suspension, they hit something. Kind of looks like there's some damage on the roof line also, but I can't tell. Anyway. So looking at this, vandalism, missing the steering column shroud, and they don't show the ignition here. Usually they take it from the other angle, and I would say 99% of the time they take it from the other angle, right from the center of the car, instead of tilting down the seat and then taking it from that angle. Now, that's not positive, but look, it's still, they still avoided showing the ignition. So Suspicious, yes. I don't think there was anything worth or any other pictures worth showing. But the one thing I do want to see is the VIN. So what we're going to do is we're going to take down the VIN. And I had another Honda there that was really suspect, but I think I came down to the conclusion it really just wasn't. It just looked like it was. G4A 31 G716. They do that just to, I don't know. So I don't know why they do it, but it definitely makes it more difficult to look at. You can see right there the asterisk. I can't see anything about that, so I'm going to put it in the bumper. We're going to see what it says. Now we're also going to use one other resource. We're going to put it into the VIN check. Oh, shoot. And this will actually say, usually it'll say when it was actually, or if the car was ever reported as theft, but it doesn't necessarily have to be reported to this system. I'm going to VIN check, I'm going to double check, and then I'm going to put it into lookup VIN. Make sure that's all the way at the end. Go to agree to terms, and then I'm not a robot, and then search VIN. Total loss recorded. Oh, theft recorded. There we go. So that actually says it was theft. It was a theft, and that's not what Copart is selling it as. It's selling it as vandalism. That right there is fraud. And okay, so I'm going to have this read it real quick. I don't know if you'll hear it. I'm going to go ahead and
when a company is required to disclose a vehicle's history, including whether it has been rebuilt, salvaged, or stolen. This is commonly referred to as title branding disclosure or full vehicle history disclosure. Below are the key terms and legal frameworks associated with this practice. 1. Title branding disclosure. Definition: laws requiring that a vehicle's title must clearly indicate its history if it has been rebuilt, salvaged. The vehicle was declared a total loss by an insurance company and repaired to meet road safety standards. Stolen, recovered, if the vehicle was reported stolen and later recovered. Purpose: to protect consumers from unknowingly purchasing vehicles with significant damage or history that could impact safety, reliability, or value.
Okay, number 2.
The Federal Truth in Mileage Act. Requirement: dealers must disclose the accurate odometer reading and inform buyers if a vehicle's odometer has been tampered with or replaced. Relevance: this act overlaps with title disclosure, as significant repairs or theft may impact odometer accuracy. The Uniform Commercial Code, UCC. Requirement: businesses engaging in vehicle sales must avoid fraudulent practices, including withholding critical vehicle history information. Application: non-disclosure of a rebuild or theft history may be considered deceptive under state or federal laws. State-specific disclosure laws. States may have individual laws requiring dealers to disclose salvage, rebuilt titles, inform buyers if a vehicle has a branded title, provide vehicle history reports. Many states mandate dealers to give access to a Carfax or similar report upon request. Magnuson-Moss Warranty Act. Requirement. If a vehicle is sold with a warranty, the seller must disclose any significant repairs or past damage to avoid voiding warranty protections. Relevance. Applies to both rebuilt and stolen, recovered vehicles that may have undergone extensive repairs. FTC's used car rule. Requirement. The Federal Trade Commission requires used car dealers to display a buyer's guide on each vehicle. This guide must include disclosure of salvage titles, significant defects or prior conditions, including theft or damage.
And I'm going to actually ask what it's called. Or so this actually, it actually violates numerous different acts, including like the auction. Copart's part of an auction group. So what I asked it was, I said, the auction group that Copart belongs to, what are they violating when they do not disclose theft history, or if the car was rebuilt? Do they violate their own customer pledge? And here's what it had to say.
If an auction group like Copart fails to disclose theft history or that a vehicle was rebuilt, it may potentially violate 1. Consumer protection laws. Federal Trade Commission, FTC. The FTC's used car rule requires sellers, including auction houses, to provide truthful and complete information about a vehicle's condition, including any known defects, branded titles, salvage, rebuild, or other significant history. Non-disclosure of theft or rebuild history may be considered deceptive or unfair practices under the FTC Act. State-specific disclosure laws. Many states require that sellers disclose whether a vehicle has a branded title, salvage or rebuilt, or has been involved in significant damage or theft. Failing to do so could result in penalties, fines, or legal action.
So I asked if selling on a bill of sale excludes them from disclosing the history. Does selling the vehicle on a bill of sale exclude them from including history? And here's what it said.
Selling a vehicle on a bill of sale may alter the seller's legal obligations in some jurisdictions, but it generally does not exempt them from disclosing critical vehicle history, especially if required by law or if the seller knows significant details about the vehicle. Here's a breakdown. Legal and title disclosure obligations. Salvage or rebuild titles. In most U.S. states, sellers are legally required to disclose if a vehicle has a salvage, rebuild, or other branded title, regardless of whether the vehicle is sold with a formal title or a bill of sale. Selling on a bill of sale does not exempt the seller from complying with these state or federal requirements. National Motor Vehicle Title Information System, NMVTIS, federal law requires reporting vehicles with salvage, rebuild, or junk titles to NMVTIS. Buyers can access this database to verify history, regardless of the sale method.
As we can see there, they're required. It doesn't matter. And I actually have an email from them saying, well, you bought it on a bill of sale as is. Not true.
Disclosure of theft history. Known history. Even with a bill of sale, a seller may be legally or ethically required to disclose known theft history, especially if the vehicle was previously reported stolen and recovered. Non-disclosure of theft history can lead to claims of misrepresentation or fraud, depending on the state's consumer protection laws. Bill of sale and as-is sales. As-is disclaimer. Many bills of sale include as-is language, indicating the buyer accepts the vehicle in its current condition without warranties. However, as-is sales do not shield the seller from fraud or misrepresentation. If the seller knowingly conceals critical information.
Note that right there. It says, however, as-is sales do not shield the seller from fraud or misrepresentation. If the seller knowingly conceals critical information, e.g., theft history or rebuilt status, the buyer may have legal recourse.
State-specific exceptions. Some states, such as California and New York, have strict disclosure laws requiring sellers to provide specific information about the vehicle's history, even in private sales. Auction houses and bills of sale. Auction sales practices. Companies like Copart often sell vehicles under a bill of sale, particularly for salvage or non-roadworthy vehicles. While this simplifies the sale process, it does not exclude them from disclosing critical history like salvage or rebuild status, theft or total loss history. Most auction companies include disclaimers advising buyers to verify the vehicle's history independently but may still be subject to legal challenges if critical information is withheld.
So the other one actually said, and I'm going to go back to this one real quick here because I didn't show it to you. On the VIN check, the Honda I was talking about says total loss record. And that total loss was over $256. In other words, so here we go right here. One owner, no opens, and no damage or theft, right? So we're not seeing anything here. But if I go back to chat, and if I look back in my history, because I actually looked this one up, it said sedan, blah, blah, blah. It gave me all the specs first, because that's what I asked for last time. And then I said, what about its history? Was it stolen? Look at other sites. And it said, has a notable history involving vandalism. Here's a summary of the available. It says Copart auction. It was September 29, 2023. Lot number, blah, blah. Primary damage was vandalism. Minor dents and scratches. New York Salvage. Value was 26,000, and the repair estimates was 256. There's something wrong with that. And then we go back to the VIN check, and it says total loss. Why would it be a total loss for $256 if over $256 is not a total loss unless it was actually stolen and not recovered until after it was paid out. This is what you have to look for. You have to watch for vandalism. That's what they said. So in order to find these, all I did was type in vandalism. And I can go back to, there's the Honda right there. It's still in, it says lot no longer exists. Hang on one second. Let's see. That's very interesting, actually. Now it's gone. Why is it gone? This one has 175,000 miles on it. It's Florida's certificate of title. Vandalism. You want to bet the ignition's missing? Yep, right there. But they called it vandalism. Now everything we read Okay, so I'm going to ask, is it fraud? They know. So I wrote, is it fraud when they know the car had been rebuilt or stolen, and they list it as front end damage or vandalism? And its response was,
Yes, it could be considered fraud if a seller knowingly misrepresents or conceals a vehicle's history, such as being rebuilt or stolen, by listing it under misleading descriptions like front-end damage or vandalism. Fraud involves intentional deception for personal or financial gain, and this scenario could meet that definition under various consumer protection laws. Here's why.
okay, so you can look it up yourself with legal definitions.
Legal definition of fraud. Fraud typically requires the following elements. Misrepresentation. The seller provides false or misleading information, e.g., failing to disclose the rebuilt or stolen history. Knowledge. The seller is aware that the information is inaccurate or incomplete. Intent to deceive. The seller intends for the buyer to rely on the misrepresentation. Damage. The buyer suffers harm, financial or otherwise, as a result of relying on the false information. If a company like Copart knowingly labels a rebuilt or stolen vehicle as having minor damage, e.g., front-end damage or vandalism, without disclosing its true history, they may be committing fraud. Applicable laws and regulations. Federal Trade Commission, FTC, rules. The FTC prohibits unfair or deceptive practices under the FTC Act. Misrepresenting a vehicle's condition or failing to disclose key facts could violate this law. State consumer protection laws. Most states require sellers, including auction houses, to disclose branded titles, e.g., salvage, rebuilt, and known theft histories. Misrepresenting a vehicle's history can lead to legal consequences under state lemon laws, fraud statutes, or unfair trade practices acts. Uniform Commercial Code, UCC. Under the UCC, sellers must act in good faith and disclose material facts about a product. Hiding a vehicle's rebuilt or stolen status breaches these obligations.
So does committing fraud when selling a vehicle render their arbitration laws and their court shopping void? Yes, committing fraud. I'll just have it read it again.
Yes, committing fraud during the sale of a vehicle could potentially render arbitration agreements or forum selection clauses used for court shopping unenforceable under certain circumstances. Here's why. 1. Legal principle. Fraud invalidates contracts. Fraud undermines the very basis of any agreement, including arbitration clauses and forum selection clauses. If a seller or auction group like Copart commits fraud, courts may determine that arbitration agreements are void. Fraudulent activity can void arbitration clauses if the fraud pertains directly to the agreement or the underlying transaction. Courts are less likely to enforce arbitration when it appears that arbitration is being used to shield deceptive practices. Forum selection clauses are void. Courts may disregard clauses that specify jurisdiction, e.g., requiring disputes to be heard in a seller-friendly court, if fraud or bad faith is involved. Example, if a buyer argues that fraud induced them into purchasing the vehicle, the arbitration agreement or court selection clause may not stand because it was part of a larger deceptive act. Key legal doctrines. A. Fraud in the inducement. Definition. Fraud that induces someone to agree to a contract, e.g., misrepresenting the condition of a vehicle to secure a sale. Impact. If a buyer proves fraud in the inducement, the entire agreement, including arbitration clauses, can be voided. B. Unconscionability. Definition. An agreement is unconscionable if it is grossly unfair or one-sided. Impact. If fraud is combined with unfair arbitration rules, e.g., high costs or biased processes, courts may refuse to enforce the agreement. C. Public policy. Contracts that attempt to limit remedies for fraud or misrepresentation may be invalidated as they violate public policy. Courts prioritize protecting consumers over enforcing unfair agreements.
Now, all three of those actually apply to Washington State, and I think that they apply to New York and California as well. There may be other states. I would have to look, or you would have to look. Someone could ask me, and I can look for you. But these three right here actually make it so I can go down to the courts and file a lawsuit against them here. Their arbitration rules state that you have to actually arbitrate in Texas. Um, and you cannot take them to court without first arbitration, which means you have to arbitrate in Texas, which poses a significant barrier, which goes back to
P. If a buyer proves fraud in the inducement, the entire agreement, including arbitration clauses, can be voided.
Sorry, unconscionable. So it goes back to this one right here. It says an agreement is unconscionable if it grossly unfair to one or one-sided. If a fraud is combined with unfair arbitration rules, e.g. high costs, which means you have to arbitrate in Texas, which is high costs, courts may refuse to enforce the agreements. So they can come to the courts and say, hey, this must be, they might go to the court in Washington and say, this must be arbitrated in Texas according to our arbitration rules. And you can actually come back and say, well, this is unconscionable and it was fraud. So because it was unconscionable and it's fraud, the court has in the past actually ruled, and this is the only ruling against Copart that I'm aware of, they actually ruled that their arbitration rules are not fair, and it was allowed to be tried in Washington state. So I know that this wasn't supposed to be this, I wasn't supposed to be talking about this, but here I am.
Case law and precedent. Courts across the U.S. have voided arbitration and forum selection clauses when fraud was a factor. Fraudulent transactions, arbitration clauses have been invalidated where fraud was central to the dispute. Consumer protection cases. Many states have consumer protection laws that explicitly allow buyers to bypass arbitration in cases involving fraud or deception.
And there you go. So many cases, or many states have consumer protection laws that explicitly allow buyers to bypass arbitration in cases involving fraud or deception, which basically says those arbitration laws that they say, it's a non-starter. Federal and state protections. You got Federal Arbitration Act. So let me have you read it. Have it read it. Reads it much better than I do.
Federal Arbitration Act, FAA. While the FAA generally enforces arbitration agreements, it does not mandate enforcement when fraud is proven. State consumer protection laws. Many states, such as California and New York, provide specific exemptions allowing buyers to litigate in court when fraud or misrepresentation is involved.
Let's go to the next one.
Practical implications for fraudulent sellers. Arbitration agreements become useless. Buyers may challenge arbitration clauses and successfully argue that fraud nullifies the agreement. Court selection clauses may be ignored. Buyers can pursue legal action in their own jurisdiction rather than being forced into seller-friendly venues. Class action waivers can be challenged. Fraudulent practices might also open the door for class actions, bypassing individual arbitration agreements. What buyers can do. Document the fraud. Gather evidence of misrepresentation, e.g., photos, auction listings, vehicle history reports. File a complaint. Report suspected fraud to the Federal Trade Commission, FTC complaint form. State Attorney General's Office, Better Business Bureau, BBB, challenge arbitration. Work with an attorney to argue that the arbitration clause is invalid due to fraud.
So I haven't actually filed with the FTC, State Attorney General's Office, or the Better Business Bureau because I was actually looking for attorneys to take my case. Now I'm actually going to file with all three and see where that goes. I had something else on my mind and completely forgot it.
What buyers can do. Document the fraud. Gather evidence of misrepresentation, e.g., photos, auction listings, vehicle history reports.
Right there. So what buyers can do and document. So I wanted to actually come back and show you something. And I don't, which is interesting because I don't think that I actually, I don't think that I actually printed the page out, which I probably should have. See, this one's definitely stolen, which is unfortunate because it runs and drives. It's got 175,000 miles on it. My bet is it probably has a new engine in it. It looks good. That's minor damage to it. And it has a certificate of title. That's really weird. So this one doesn't even have, wow. Wow. So I'm going to do another VIN check here. Oops. Yeah. Is that right? 252, right? Double checking here. 252, absolutely. Theft record. Total loss. That doesn't get any worse than that. I am looking right at that VIN. And of course it's recorded as vandalism. Now I want to show you the car that I actually purchased. Lots one. No, go back further. This one right here. It says front end damage, side damage. Doesn't say anything about theft. And I'm pretty sure the VIN check doesn't say anything either, if I remember correctly. We'll go ahead and click on that. And then everybody said, well, you should have done your due diligence. I'm like, really? Due diligence? I literally checked. So let's see. If you don't have those spaces gone, it won't do it. Wow. So there we go. Total loss. And again, theft record. They didn't disclose either one of these. You see it plain and simple right here. Front end and side damage. This is the vehicle I purchased. 2016 Hyundai Sonata. 122,000 miles. By the way, remember I said 123,000 miles is what I see usually wrecked. There you go. Yeah, lot sold. Lot sold was sold to me. And everybody said, "Oh, well, you only bought it for $500. Quit whining." It's like, well, you're right. It wasn't a lot. By the time I had it shipped to me, it was over $1,000. You know, I mean, it's not like anybody ever likes to throw away money. I'm not angry about the money. I'm angry about the principle of what they did. So anyway, so I have effectively shown how Copart actually sells consistently stolen vehicles under vandalism. But they use other things like side damage, like I showed, front side damage. And the only thing I didn't know, and I looked at everything, I had never purchased a vehicle before that was a theft. And I didn't really vandalism. I didn't really think to look at the ignition. So that part really sucks. It was a crappy thing for them to do. I cannot spell tonight. And there we go. So we got more vandalism. This one's a vandalism. I can't tell on this one. I actually did look this one up earlier. I can't tell if this was a theft history or not, but we can look up the VIN number maybe and see. You see, this one says vandalism on it also. So, yeah, I'm pretty sure I tried looking up this number, but let's see. So that's 55SWF8 DB6 KU 310398. Okay. Just double checking here. I mean, so far I've shown you three cars that were not theft. And there's theft number 4, theft record. There we go. Total loss, 10/20, October 2024. Cause of loss, VNMM. I wonder what that means. So in the context of cars and insurance, cause of loss, VNMM, typically stands for vandalism and malicious mischief. Here's what it means. That is so messed up.
VNMM defined. Vandalism, intentional damage caused to the vehicle by someone without the owner's consent. This can include acts like graffiti, broken windows, slashed tires, or other forms of deliberate destruction. Malicious mischief, damage caused out of malice or intent to harm, which may not necessarily involve extensive destruction but still results in a financial loss for the owner.
Okay, so that begs the question, can people pass off vandalism for theft? Okay, so this should be eye-opening. I'm not trying
Selling
to
a car is vandalized when it has actually been stolen without disclosing the theft history is potentially deceptive and could violate consumer protection laws. State title branding regulations and federal laws like the National Motor Vehicle Title Information System, NMVTIS, requirements. Here's why.
Okay, so here's what I said.
Is Copart getting away with saying the car was vandalized trying to use it as a gray zone instead of saying theft?
And then here's how ChatGPT responded.
If Copart or any other auction company consistently labels vehicles as vandalized when they know the cars were stolen and recovered, this could indeed be seen as an attempt to exploit a gray zone to avoid explicitly disclosing theft history. While this practice might not always violate the letter of the law, it could raise serious legal, ethical, and consumer protection issues. Here's an analysis of why this might be happening and whether it's legitimate. Why might Copart list a stolen vehicle as vandalized? Avoiding stigma. Vehicles labeled as stolen and recovered often carry a stigma that reduces buyer confidence and resale value. Vandalized might sound less severe and could make the vehicle more appealing. Title and branding variations. Some states do not issue special branding for recovered theft vehicles unless they are deemed total losses by insurance companies. In such cases, Copart might list the vehicle's damage description, e.g., vandalism, without explicitly mentioning theft, relying on the buyer to investigate further. Lack of clear reporting requirements. If the car was stolen but recovered without insurance involvement or significant damage, the theft might not appear in official records, e.g., NMVTIS. This could allow Copart to claim they're relying on available data.
And that's what they do, is they rely on available data. I've actually heard that specific statement made.
Is this practice legal? Federal laws. National Motor Vehicle Title Information System, NMVTIS. Copart is required to report vehicles with branded titles, e.g., salvage, rebuilt, junk, or theft history to NMVTIS. Failing to disclose theft history known to them could violate this federal law.
See, that opens them up for a class action lawsuit right there, because they're not doing that, and they're doing it on a national level. This isn't even just like one Copart. This is multiple Coparts, and there is multiple Coparts in each one of the states. So we're talking, I think it's close to like 300, at least 300 locations. Well, good question. Let's see what it says about gray zone real quick.
Gray zone interpretation. While Copart may argue they're labeling the vehicle based on the visible damage, e.g., vandalism from attempted theft, if they know or have reason to believe the vehicle was stolen. This could be seen as misrepresentation or fraud. Is vandalism a legitimate description? Possible scenarios. If a stolen vehicle was recovered with physical damage, e.g., scratches, broken locks, smashed windows, listing it as vandalized might describe the damage, but not the cause of loss. Omitting the theft history while focusing solely on the damage could mislead buyers into believing the car was never stolen. Responsibility to disclose. If Copart knows the vehicle was stolen, simply describing the visible damage, e.g., vandalism, without mentioning the theft history could be deceptive.
Notice it says could be, because the law is never black and white. And so it says could be, but it really is.
Why this might be problematic for Copart. Trust issues. Misrepresentation erodes consumer trust, particularly for buyers relying on Copart's descriptions to make informed decisions. Legal risk. Fraud claims. Buyers could argue they were misled if Copart withheld theft history. Regulatory action. Mislabeling vehicles could attract scrutiny from agencies like the FTC or state attorneys general. Ethical concerns. Even if technically legal in some jurisdictions, omitting theft history in favor of vandalism raises ethical questions about transparency.
So let's just go to the conclusion, cut to the chase here.
Conclusion. If Copart is knowingly listing stolen cars as vandalized to avoid disclosing theft history, this could constitute fraudulent misrepresentation or at least an unethical practice. While they may argue it falls within a gray area, the responsibility to be transparent about a vehicle's history remains critical. Buyers should exercise caution and verify all information independently.
Okay, this is the question I just asked.
How many Copart locations are they prone to a class action lawsuit? I have a car in my front yard that was classed as a theft and total loss and listed as front end and side damage.
Yeah, that was my questions. And now here we go.
Number of Copart locations. Copart operates an extensive network of locations globally, with the majority of its facilities in the United States. United States locations. Over 200 Copart locations in the U.S. global operations. Copart also operates in other countries, including Canada, the UK, Germany, UAE, and Brazil, bringing the total number of locations to over 300 worldwide. These facilities serve as hubs for vehicle auctions, handling salvage, total loss, and clean title vehicles. Potential for a class action lawsuit. Yes, Copart could be prone to a class action lawsuit if a consistent pattern of misrepresentation, such as the one you describe, is proven. Here's why. 1. Basis for a class action lawsuit. Fraudulent misrepresentation. If Copart systematically lists vehicles with theft and total loss histories as having front end or side damage without disclosing their true condition, this could be considered fraud. Violation of consumer protection laws. Federal Trade Commission Act, FTC, misleading vehicle descriptions could violate FTC rules prohibiting unfair or deceptive trade practices. State consumer protection laws. Many states have laws requiring full disclosure of vehicle histories, including theft, salvage, and total loss designations. Breach of contract. If Copart's terms of service or customer pledge promise accurate descriptions and full disclosure, failing to uphold these promises could be grounds for legal action.
Which it does. They fail to actually hold up the customer pledge.
Evidence supporting a class action. To build a strong case, the following evidence would be critical. Consistent pattern. Multiple buyers who experienced similar issues, e.g., vehicles with theft and total loss histories mislabeled as damage only. Documented misrepresentation. Auction listings, screenshots, and descriptions showing discrepancies between listed damage and the vehicle's actual history. Vehicle history reports. VIN checks from NICB, Carfax, or AutoCheck confirming theft and total loss history not disclosed by Copart.
And we already showed 4 of them in this video alone.
Possible legal claims. Fraud, deliberate misrepresentation of vehicle condition to increase sale prices. Negligence, failing to exercise due diligence in providing accurate vehicle descriptions. Unfair business practices, violating consumer protection statutes. Breach of fiduciary duty. If buyers rely on Copart's descriptions, Copart has a duty to act in good faith and provide truthful information.
So if this was to go to court and Copart, those cars were actually used as an example, Copart could delete them from their database. However, there would still be a hole left behind because of that. They would have to either find some way to do it, and it would have to be consistent, and then they would have to explain why they hid that, which is more fraud on top of that. In fact, I think that there's probably criminal issues there.
4. Precedence of class actions against auction companies.
Taking the loss would probably be better than them actually committing criminal crimes.
Companies, including Copart, have faced lawsuits in the past for misrepresentation of vehicles' conditions, failing to disclose branded titles or history, selling vehicles with known defects without proper disclosure. These cases often settle out of court or result in policy changes.
No, this is what I've talked about in the past, and I don't know if you've ever seen the videos on it, but they always settle out of court. So that way there's no precedents or proceedings. Now, the one in Washington about, what's it called? The one in Washington that established that it could be heard in Washington State instead of Texas. That one's on the books, and that one's actually well known. They didn't settle out of court, and therefore they lost that one. And that was a bad move on their part because they want to keep everything settled and out of court, so it doesn't establish precedents. So they lost in that area, and this is more of a ticking time bomb for them, because it's not a matter of when, it's not a matter of if, it's actually a matter of when.
Steps you can take. If you have evidence of misrepresentation for the vehicle in your yard, here are some steps to pursue. 1. Verify the vehicle's history. NICB VIN check. NICB VIN check, free resource to check theft or salvage records. NMVTIS report. Obtain a report from a paid service like Carfax or AutoCheck to confirm total loss and theft history. 2. Document the misrepresentation. Save all evidence, including the original Copart listing, vehicle history reports showing discrepancies, photos of the vehicle as received.
Now it says file complaint, Federal Trade Commission, State Attorney General's, and Better Business Bureau. I haven't done any of these, but I did try to consult an attorney, and they just kept. I've actually consulted like three, or tried to consult three, and they said that they wouldn't be able to handle it. And I'm just like, well, that is a major lawsuit, but they're looking at the money and saying, oh, well, you can only recover like $1,000. It wasn't about the $1,000, and there's reasons for suing above and beyond costs. Okay, so I just asked, this is my ask.
What are the reasons to sue above and beyond the loss of financial means to include slapping them with a fee that would deter them from practicing the same methods? To pursue legal action against a company like Copart for misrepresenting vehicle history, you can consider causes of action and legal arguments beyond mere financial losses. These claims could justify punitive damages or regulatory penalties designed to deter similar practices in the future. Here's an outline of reasons to sue and the associated legal remedies. Fraudulent misrepresentation. Definition: deliberate deception by providing false or incomplete information to induce a buyer to make a purchase. Legal basis: Copart knowingly misrepresented or concealed critical information, e.g., theft or total loss history, by listing vehicles with misleading descriptions, e.g., vandalized instead of stolen. Remedies: financial damages to recover the difference between the car's actual value and the amount paid. Punitive damages to penalize Copart for intentional or reckless fraud, deterring future misconduct.
See, punitive damages. So even though I only lost $1,000, a lot of them say, oh, well, you can only hit them with like 3 times the amount you lost. But that's not necessarily true, because in such cases where you're actually going after them for punitive debt, or what is it called? Let's see here. Let's see if it says it right here. So you also do disgorgement, which is an interesting one. I think it might be punitive damages, but let's check it out. So if you only hit them with $3,000 in punitive damages, that's nothing. They're going to say, "Oh, well, here's your 3,000. Go on your way." But if you hit them with $1 million punitive damage settlement, that would make a difference. And this is what I was trying to say to the attorneys: hey, here's the, hit them with a punitive damage, lawsuit. Now, the attorney general could actually file that on your behalf and hit them with that, and then you could be the recipient of that, which I think that's my next course of action, since I couldn't find an attorney to actually help me out. So what we're going to do here, so
The amount of punitive damages awarded in a lawsuit is determined by several factors and varies widely depending on the severity of the misconduct, the impact on the victims, and the financial resources of the company being penalized. Courts and juries aim to set punitive damages high enough to deter future misconduct without being deemed excessive. Below is an explanation of how punitive damages are calculated and capped. Factors that influence punitive damages. A. Degree of misconduct. Egregiousness: the more willful, malicious, or reckless the fraud, the higher the punitive damages. Courts look for patterns of intentional deception or blatant disregard for consumer rights. Systemic nature: if the company's actions were part of a larger pattern of fraud affecting many consumers, punitive damages can be significant. B. Impact on victims. Harm caused: the greater the financial loss or emotional distress caused by the fraud, the higher the punitive award. Number of victims. Class action lawsuits involving multiple plaintiffs often result in larger punitive damages to reflect the widespread harm. C. Company's financial resources. Deterrence: punitive damages must be large enough to impact the company and discourage similar behavior. For large corporations like Copart, courts may award punitive damages in the millions to ensure deterrence. Ability to pay: courts consider the company's net worth, revenues, and profits when setting punitive damages.
So there you go, right there. So this is what I was trying to tell the attorneys: is you can sue for punitive damages and like sue for $1 million or something like that. So I'm looking at, so it says examples here. Let's go to the punitive damages multiplier.
Punitive damages multipliers. Courts often calculate punitive damages as a multiple of the compensatory damages, actual damages awarded to the plaintiff. Typical ratios include 1-to-1 ratio, for less severe cases. 3-to-1 ratio, common in cases involving intentional misconduct or fraud, i.e., punitive damages are 3 times the compensatory damages. 10-to-1 ratio, used in extreme cases of egregious, malicious, or widespread fraud. Example: if you suffered $50,000 in financial losses due to fraud, punitive damages could range from $50,000, 1-to-1, to $500,000, 10-to-1, or more, depending on the severity of the misconduct. Supreme Court guidance on punitive damages. The U.S. Supreme Court has issued rulings to guide courts on the limits of punitive damages. Excessiveness test: punitive damages must bear a reasonable relationship to the actual harm caused. General cap: ratios exceeding 9-to-1 are often considered excessive unless extraordinary circumstances exist. Notable Supreme Court cases. BMW vs. Gore, 1996. The court struck down punitive damages 500 times larger than the compensatory damages as unconstitutional. State Farm vs. Campbell, 2003, suggested a general punitive to compensatory damages ratio of 10-to-1 as a reasonable upper limit in most cases.
It says most cases. So in this case, you're suing a billion-dollar company here, and you want to make a point because they're all doing it. They're doing it at all locations. As you notice that when I was looking at Copart, I wasn't looking at a specific location. I was actually just looking at, well, evidently this one's got Pasco, Washington, and stuff like that. But when I looked and did a search, I didn't put in a location. So let's see if we can do location here. Let's go to reset. Oh, that said body style. Maybe reset? No. So we can go to, let's see. We'll put in 2,000 miles as the limit, right? 98837, 2,000 miles. And it's just showing me the closest places. But what if I did Florida? Or California, for example? Nevada, Utah, Colorado, Arizona. I don't see Florida in here. Okay, so here's what we got. We got a list. Here's a Santa Fe right here. Vandalism. It does have the ignition set. So let's see. Go ahead and take that number. And let's go to go back to bin check. Looks a little bit different because I reduced the size of the. So I've exceeded my number of allowed the 24-hour period, which sucks. But we did have multiples that we actually saw, and I'm betting this one says vandalism on it. Same situation. Let's go ahead and there's another one. There's a Hyundai Accent. Mostly we're just looking for the ignitions missing, and they sell them as, see, another one, ignition missing. They're selling it as vandalism. And we got the lots and the lot numbers. So this is all on video, so it's not like they can hide it. Let's see here, Kia. This is in Reno also. And I'm just trying to look for a significant amount. BMW. This one is missing the ignition stuff also. It's vandalism. I really haven't looked at all the other ones, mostly Kias or Kias and Hyundais. But I mean, there's other stuff out there as well being sold. Didn't I just looked at that red one. Let's see about this accent. I think we did look at this accent already. And it was missing the column. Yep. So what about the venue? I don't know if I've ever noticed any venues actually with that problem, but yeah, it's missing the ignition also. Let's go ahead and enhance it. The unfortunate part is they take really shoddy pictures of the ones that are actually vandalized, which technically are theft recoveries. And of course, farmers insurance. Another Kia Soul, rather than the venue. Let's see. Yep. And why is that picture or that photo so crappy? As you can see, the carnage right there, missing that. Marked as vandalism. It's quite possible that this one was a theft. Oh, yeah, right there. They didn't have to actually yank that out. They just yanked the wires out. But yet they're selling it as vandalism. Let's see about the Volvo. This is an interesting one because the security is a little bit higher. It does say vandalism though. 75,000 miles. CSAA. That's seen that a couple times now. No column, so I can't be for sure because I can't look it up since I'm at my max for the day. Let me try one thing though. New private window. And yep, I can do it like that. Don't do it, cat. Seriously. Nope, still says I exceeded my allowed 24 hours. Okay, well, that is what it is. Anyway, I just want to add a few more to this because I want to capture the fact that they are doing this on a regular. It's not just me. So here's the one missing the window. That's how they got into the car. They're selling it as vandalism.
Here are the product. Schlade Kens 625 and code plus Wi-Fi deadbolt.
Alexa, stop. Nice car. I like it. Elantra. I don't see the ignition being hit on this one. Definitely has a key ignition, and I don't see any keys. It does have keys, though, it says. Another vandalism. Nope, can't tell on that one. This one's missing the windshield or the window. Vandalism. Oh, that's definitely vandalism. And see, I can see that. And maybe they'll have to start stripping the vehicles to actually make it sound like vandalism, which they'll definitely get more or less for. And that's what they were trying to avoid by actually calling it theft recovery anyway. This one's definitely vandalism. And I'm okay with ones that actually look like vandalism. Like this windshield, somebody threw something into the windshield twice, not just once. You know, knocked off the mirror, busted the front end up. That's vandalism. You know, knocked the window out. That's definitely vandalism right there. You know, I mean, that's a busted out window. That was a